Today, I would like to talk to you about the condemnation process. Several governmental and quasi-governmental entities have the power of condemnation. For our purposes, I am going to assume that the NCDOT, the Department of Transportation, is the condemnor, or the entity taking private property. I will further assume that the property owner, otherwise known as the condemnee, has decided to not hire an attorney. Assuming that your property is on an NCDOT highway corridor project, you will probably first hear about it from an NCDOT right-of-way agent. You might also hear about it from family, friends, media, social media. So what is a right-of-way agent? A right-of-way agent is employed by land acquisition companies who act as third-party contractors to the DOT. The agent's job is to have the initial contact with the property owner, explain to them the process, explain to them how the project is affecting their property, and then try to effect a settlement with them. Once it becomes obvious that a settlement cannot be reached and the agent has reached her authority, the case will be sent to Raleigh, where there will be a filing of a complaint. The first correspondence you get from the right-of-way agent will probably be a letter inviting you to a public meeting. At the meeting, DOT representatives will be there with maps, photographs, maybe some videos to help you understand the process and to explain what the project is going to look like from start to finish and how the project is going to affect all the parcels on the project. We encourage you to attend these meetings, ask as many questions as you can, talk to your family and friends who might also be affected by the project, and take whatever documents are available. One thing to keep in mind is that DOT rarely takes all of your property or any of the improvements on your property. When DOT takes less than the entirety of the property, it is called a partial taking. If DOT takes all of the property or enough of it so that what is left has no economic value, that is called a total take. Sometimes the DOT will take your primary residence. That is handled a different way, and that's a subject for a different video. At some point, you'll be contacted by the agent again, letting you know that DOT is getting ready to start the project. At that time, the right-of-way agent will try to set up a meeting with you where a DOT appraiser can visit your property, inspect it, and come up with a value that they believe you are entitled to for what DOT is acquiring. When the appraiser comes to do her job, she will want to walk the perimeter of your property, taking photographs, taking measurements. She might also want to walk the interior of your home. Again, taking photographs, taking measurements. You are encouraged to accompany her while she walks your property. There are things that you might know about the property that she does not. Some important things to mention to the appraiser are any recent improvements you've made to the property, such as a new roof or a new HVAC system. Things that increase the value of your property that the appraiser might not know about. One thing to keep in mind is that the appraiser does not care about the cleanliness or messiness of your home. It is not going to affect the value that they assign to it. Once the appraiser has finished her report, she will send it to the NCDOT review appraiser. Assuming it is approved, DOT will send you a copy of the appraisal report along with an offer letter offering you the amount of money that DOT has determined your acquisition is worth. This is called DOT's initial offer. At this point, you are welcome to enter into negotiations with the right-of-way agent to try to get more money than what they are offering. Remember, the person you're negotiating with is usually the same person who is very nice in explaining the process to you, explaining the project, arranging the appraisal, all of those things. She might not be as nice while she's negotiating with you. The agent's job is to settle the case as quickly and cheaply as possible. If you are satisfied with the amount of money DOT has offered you, you can let them know that you're happy, you don't want to negotiate, and in time, DOT will send you a check with some documents that you need to sign, and that should be end of the interaction with the DOT until such time as they start work on your property, where you still might have some issues to deal with them, but hopefully not. If you are not satisfied with the offer, as I said, you can enter into settlement negotiations. At some point, the right-of-way agent will reach the limit of her authority, and she cannot offer you any more money. At this point, again, you're free to take whatever she can offer you or to refuse it. If you refuse her highest offer, the case will be sent to the NCDOT, where there are several DOT attorneys who will file a complaint and then, simultaneous with the complaint, deposit with the clerk of court the amount of money representing their initial offer. That money that gets deposited into the court is yours to withdraw if you want to, or you can keep it with the clerk until such time as a settlement is reached or a trial results in a verdict. If you decide to withdraw DOT's initial offer, it is a credit against any further money you might get during the litigation. Let's use an example. DOT determines that what's being acquired by them is worth $50,000. They deposit $50,000 with the clerk of the court. You decide to withdraw that money, as is your right. You continue to negotiate with DOT. The case goes to mediation and is settled for $100,000. If you withdrew that money, the $50,000, DOT owes you another $50,000. If you did not withdraw the money, DOT owes you $100,000. At Henson Fuerst, we believe that it is often beneficial for the property owner to allow NCDOT to file suit. First, you will now be dealing with an attorney who has incentive to get the case settled so that they can move on to another case. Second, the DOT attorney is dealing with a negotiator who has more authority than the right-of-way agent and who also understands the value of getting these cases settled and moving forward. The downside for some owners is that there is now a lawsuit out there against them where they are the named defendant. If you're uncomfortable with this, just feel free to take the best settlement you can and move on. You need to be comfortable with the process. Assuming suit is filed, you are still free to continue negotiations, but this time you will be dealing with the NCDOT attorney. And as I said, sometimes this is a better situation for the property owner. But letting the DOT file suit does come with some risks. First, they might serve you with discovery demands. Answering discovery demands can be very time-consuming. Second, DOT might want to take your deposition under oath. Again, this can be time-consuming, costly, and dangerous. It is also against your best interest to be deposed by an experienced attorney without somebody representing your interests. Third, at some point during the litigation, if the case is not settled, you will be compelled to attend mediation. Mediation can be costly and time-consuming. Most cases do settle at or before mediation, but if it does not settle at mediation, the case will go to trial. Most condemnation trials last approximately 1 week, sometimes a little bit shorter, sometimes a little bit longer. You will be allowed to testify about the value of your property, but you will be at a disadvantage against an experienced attorney and appraiser. That means you will probably need to hire some sort of an expert at trial. Even if your appraiser does not write a report, her services will not come cheap. All of these events, depositions, mediation, discovery, trials, they can all take place whether or not you are represented by an attorney. The most important thing you get from an attorney is experience. Condemnation is a unique area of law, and there are very few attorneys in North Carolina who practice it. At Henson Fuerst, our condemnation attorneys have over 20 years of combined experience in condemnation, including 8 years representing the NCDOT in their condemnation proceedings against property owners. We spend time interacting with NCDOT attorneys and right-of-way agents on a daily basis, and we have good relationships with them, and we are perceived as being trustworthy and good to deal with. Another reason that you might want to hire an attorney is that most condemnation attorneys work on what is called a contingency fee basis. What that means is that you pay nothing up front. Your attorney's fees are contingent on how much the case settles for. The typical arrangement, and the one that we use at Henson Fuerst, is to take 1/3 of the client's total recovery above DOT's initial offer. Let's use some easy math to demonstrate. DOT's initial offer is $100,000. We represent you and we are able to get a settlement for $400,000. The difference is $300,000. Henson Fuerst takes 1/3 of that, or $100,000. The property owner takes 2/3, or $200,000, plus the $100,000 initial offer. So from the $400,000 settlement, Henson Fuerst takes $100,000, and the property owner takes $300,000. So the attorneys and the property owner are both incentivized to try to get the most money possible for the property owner. We do have to recoup any fees that we might advance on your behalf, such as paying for experts, depositions, mediations. We will pay these expenses for you during litigation and get it back when the case settles. We will not nickel and dime you for things like copying charges, mileage, and postage. The condemnation process is fraught with peril for an inexperienced property owner. Should your property be subject to condemnation, we encourage you to at least speak to an attorney or several attorneys, and then you can decide whether or not you want to hire one. Should you want to, we hope that you will consider Henson Fuerst. Thank you.